Good evening, everybody. It's Wednesday night, and we're back here on the Coalition Radio Network with Calenda, attorney at law. I'm Chaz Calenda. I'm an attorney at the law firm of Inman and Torgy here in Rhode Island, Coventry, Rhode Island, and I am your host, as I am on Wednesday nights here on the Coalition Radio Network, to discuss various legal issues here affecting us in Rhode Island and political topics that we are all looking at with great interest now that election season is upon us. Tonight, to join me to discuss the topics of the state of Rhode Island gun laws post the Supreme Court case in New York State Association, Rifle and Pistol Association versus Bruen, is Coalition Radio host management, Pat Ford, and we will discuss the implications, the actual implications of what that case means here for Rhode Island Second Amendment rights. Pat, thank you as always for joining me. Yeah, I think that's a great way to look at this, Pat, because unfortunately, all too often, we've seen uh, issues like the Second Amendment and the rights enshrined in the Second Amendment looked through and talked about in a overly partisan, one-sided manner from wherever it comes from. But when we listen to um, people like our current Attorney General, people like the Attorneys General of the states that were principally affected by this Bruen decision, states like New York, Massachusetts, California. Those are the types of states we hear it talking about it as if um, the Second Amendment has overtaken all public safety issues. The Supreme Court's gone wild. That's just simply not the case. And I think the majority in the Supreme Court put that very well. And they said we've really done nothing but reiterate what we've already ruled on, which was in Heller versus the District of Columbia, which they held the right to keep and bear arms was a fundamental individual constitutional right. They, although they did not reach the issue of how far that extended outside of your home at the time and back in 2008, Bruen did in fact reach that issue and held that it was likewise a fundamental individual constitutional right to carry and bear, so to speak, a firearm on your person outside your home for the purposes of self-defense. And those arms are ones that would be in use, in common use in today's society. So that obviously has huge ramifications, no matter what state you're in, because as you see, many of these states have now tried to enact laws, like Rhode Island did, that are restricting the types of weapons that are available to its citizenry, and the manner in which these firearms may be carried and the places they may be carried, just to give a few examples. So Rhode Island, as you mentioned and alluded to, Pat, this end of the General Assembly session in June, pushed through several gun control bills. The most controversial I would characterize as being the high capacity magazine ban, which was defeated in committee in the Senate, but nonetheless the House bill, which was identical, was placed on the Senate floor by a 2/3 vote of the Senate, and then subsequently passed and signed into law by the governor. So we'll get into that a little bit, but I do want to talk about the overall impact that Bruen is going to have in general, particularly in Rhode Island, and that's going to be in light of some of the more recent guidance, as in yesterday. I say recent as in yesterday, guidance issued by our Attorney General Peter Neronha as to how the Bruen case is going to affect Rhode Island concealed carry permitting. I thought it was interesting, Pat, that one day after I issue a statement that you published on the Coalition Radio Network and other outlets actually carried, that asking Peter Neronha where he stood and what he was going to do about issuing guidance in light of the Bruen decision here in Rhode Island. One day after that, lo and behold, we have so-called guidance issued by the Attorney General as to how Bruen affects Rhode Island gun law. And I'll sum it up in 2 words: status quo. Did you happen to catch that, Pat? I read the guidance and that issued by the Attorney General, and I listened to his statements on the Matt Allen show. I was not fortunate enough to listen to his statements today on the quote unquote show of record on WPRO, but I was told that he was appearing on that show today. Um, but I did read the guidance, and the guidance essentially says, because Rhode Island has a statute, which is Rhode Island General Laws 114711, which is a shall issue statute, and it does not require a proper showing of need to get that permit. Uh, Mr. Nerona interprets that as Rhode Island meeting the federal constitutional right to keep and bear arms, despite the fact that that statute does contain a suitability clause, which is defined nowhere under Rhode Island state law, and it's defined under no court case under Rhode Island Supreme Court case law. So this, one of the prime holdings, one of the core holdings, I should say, of Bruen was that governmental officials evaluating applications for concealed carry permits cannot have open-ended discretion to deny these permits. And that means that they must rely on objective criteria, objective standards when they are evaluating these applications. So, you have that presents us with the same problem we've been facing in Rhode Island for as long as the statute's been in existence, is that depending on who the licensing authority is, in this case, and the local licensing authorities are generally the police chiefs of each and every city or town in the state, depending on who is looking at your application, they may make a very different determination as to whether or not you're suitable to carry that license. And I know that's going on because I represent many people who are in that predicament. You go to one city and they look at you, as long as you're a law-abiding citizen, you have nothing that has historically disqualified you from possessing a firearm, you're going to get a permit. You go to another city or town, and I'm not going to name them because I don't think it's fair right now, but there are certain ones that have a reputation. You go to them and apply for a permit. I mean, short of you being the victim of a severely violent crime already, you're probably not going to get a permit if they even have an application. And that issue was settled long ago by the Rhode Island Superior Court back in 2000, and I want to say it was 2004 or 2003, that the Superior Court issued a writ of mandamus to a certain city or town that did not even have an application, and they were referring all of their applications to the Attorney General's office. And the Superior Court said, you can't do that. You have to accept and fairly consider the application. Yet we still have cities and towns doing that. Mr. Nerona yesterday on the Matt Allen show denied that was the case. He said in his experience, he's never heard that to be the case. But if it was, he to my surprise, my genuine surprise, offered the services of his office to make sure that those police departments would indeed accept and fairly consider your application. I am certainly going to take him up on that offer the next time I have a client walk into my office and say, I can't get an application, or this so-and-so department won't consider my application. So I'm certainly, the first call I'm going to make is over to the Attorney General's office and say, per your invitation, Mr. Nerona, I'd like you to involve yourself and inform and instruct said department to accept and fairly consider my client's application, as it is required to do. That's it. And that's exactly what the Supreme Court said is the core of the Second Amendment is your right to self-defense, the right to be armed and have that right to self-defense in the event of a confrontation, which is certainly not limited to your home. No, you're not overstating it. And if you look at the dissenting opinion in Bruin, the first 9 pages of that opinion are pretty much dedicated to talking about the mass casualty events, the shooter events, the crimes of violence by people who have used firearms and crimes of violence across the country. And there's no better example of what you're talking about than that. That is the justification that the dissent and certain segments of our population, political population, are using to justify an infringement of a fundamental constitutional right. They may not like that right. They may not like that right. There's certainly a process to go about to amend the Constitution. I believe it's been amended, 27, 28 times? What are we, this is not whether or not what side can put the most social pressure on a court or a legislator. It is whether or not we have the right, and the court says we do, and it's whose burden is it to be able to prove that any restrictions on that right are legal and constitutional. And that's where I really have an issue here with the Attorney General's guidance that he put out. Because as he rightly pointed out, Rhode Island does have 2 avenues where you can go about getting a permit to carry a firearm outside your home. One is the one the Supreme Court specifically addressed in its footnote, which is the one that the Attorney General makes reference to multiple times in his guidance. The footnote specifically takes note of Rhode Island's local licensing authority issue law. And they specifically state, we don't find a problem with that because there's no proper showing of need required. The Attorney General takes the position that because the Supreme Court said that, if applied in that way, that they don't have a problem with that, that the law that applies to his office issuing permits, 1147-18, there's no problem with that, even though that law uses word for word the language that the Supreme Court found unconstitutional in the New York statute. The proper, you may have a permit, the Attorney General may issue a permit based upon a proper showing of need. Now, he said there's no problem with that because you don't have to go through the Attorney General to get your permit. That's all well and good, but that doesn't make what is now unconstitutional okay to employ. So, I mean, if the Attorney General was only issuing permits to retired law enforcement under special standards, or only issuing permits for firearms that would otherwise be illegal, which they do have the ability to do with machine guns and issuing to retired law enforcement, if that was the only purpose of the Attorney General permit, maybe I'd agree with that interpretation, because that's not implicating the core of the Second Amendment. But because the Attorney General is issuing permits to the citizenry of Rhode Island as well, for the purposes of self-defense, theoretically, he cannot use an unconstitutional licensing scheme, despite what the Rhode Island Supreme Court said in 2004, that because there are two different ways to get it, the licensing scheme is constitutional. That was pre-Heller and that was pre-Bruen. And we're not talking about, whether or not you can get any permit in Rhode Island. We're talking about the Supreme Court of the United States said you cannot require a showing of need to get a permit, period. End of discussion. So Peter Nerona's response to that is, no, yes, we can. And I'm still going to do it. Is that bizarre, Pat? Because that's bizarre to me.
This is a highly focused, narrow interpretation of a decision that fundamentally disagrees, with, tell them a little rusty, disagrees literally with the last 25 or 30 years of Rhode Island legislation. Not only its content, not only its impact, but the direction, the course that it's been taking. As my fundamental belief is that Rhode Island law, on a very slow, gradual, and well, maybe not so slow, not so gradual after this year, basis, has sole intent is to prevent virtually every Rhode Islander possible from owning a firearm. That's the direction. And in the highly politicized speeches that were made at the bill signing ceremony, which the coalition has on video and will probably add to a very comprehensive web post on this, that was laid bare when folks were talking explicitly about gun legislation, and this was, I found, highly inappropriate, being in the State House, in the People's House, not just for good safety, but for good politics. And that just summed it all up. That laid bare exactly what the intent here. Now, I'm curious because, again, you've got a very similar political environment, in a sense, in the Commonwealth, as my buddy Matty would say. And in the Commonwealth, again, you've got an attorney general who is now has the Democratic nomination for governor. She's running only whomever the Republican primary puts up. And I happened to attend a speech of hers at of all places, the Boston Chamber of Commerce, who enthusiastically laid out the red carpet for her. So it's clear to me that the next governor of the Commonwealth of Massachusetts is going to be Maura Healey. And they came out, and we saw the Boston Globe article, but maybe you can discuss the issues raised by the state of Massachusetts and what their reaction has been.
Well, Massachusetts had to make drastic changes because they don't have a hybrid system like we do. The only people in Massachusetts that were getting firearms had to go through this May issue system. Massachusetts has enshrined into their laws ability to restrict licenses, unlike Rhode Island, although that it does get done in Rhode Island illegally, I would posit. Massachusetts has that written into their laws where your licenses are generally restricted, and particularly in places like Boston, the Boston Globe article points out, most people who receive a license to carry are heavily restricted in where they can do it and how they can do it. So Massachusetts had to make some very, I would say, very quick decisions about how they were going to react to this decision. And to her credit, although I don't probably agree with much of her politics. To her credit, the Attorney General of Massachusetts did come out and issue that guidance fairly quickly. And now you see cities like Boston, cities like Springfield, they are erasing these restrictions from existing permits, and they are no longer issuing restrictions on newly obtained permits. So that is that's a big deal,
Right.
particularly.
No,
That's
it's
a big deal, and particularly in a place like Massachusetts, which is about as deep blue as it gets.
right. And it's possibly, once you move past, say, New York and California, probably one of the most difficult states in the nation in order to own a firearm legally.
Yes, they have
Uh,
all those restrictions on the types of firearms that are even allowed within the Commonwealth.
right.
They have to be mass compliant firearms that are allowed into that state. So, she did what she was supposed to do. I don't know that the legislature is going to follow as smoothly, but when they have the chance to address state laws in Massachusetts to maybe potentially try to upend what the Supreme Court held, but the Attorney General did what she was supposed to do. We have a decision from the United States Supreme Court. We are obligated to follow it, and here is what we need to do in order to be in compliance. That was ostensibly what Attorney General Noronha was trying to do yesterday. He failed miserably, in my opinion.
Now, there are also other states in the nation that have met these same challenges. And what's been the story there from what you've been able to glean? A lot of this is highly localized news, so sometimes it's tough to get the straight story. It's easy when you've got an organization like the Globe that now effectively spans, and might be the real show record, right? But effectively spans the Commonwealth here in Little Rhodey. But generally speaking, states around the nation have fallen in line, haven't they?
Yeah, I think every state that was named by the U.S. Supreme Court in the Bruen decision, New York, Hawaii, Massachusetts, Maryland, Delaware, no, not Delaware, California, and then whatever the other ones were, they're all escaping me at the moment. But they named about 6 plus the District of Columbia that had these May issue law schemes, and they essentially, their attorneys general came out and did exactly what Attorney General Healy did, which was this is how we have to comply with the Bruen decision. Now you had states like New Jersey and New York come out and then pass laws which basically tried to deem every public place a sensitive place, where you could not carry a firearm, despite Bruen taking on that issue. Bruen said that it would be ridiculous and a violation of the Constitution if New York tried to deem all of Manhattan a sensitive place simply because it was a crowded public place. But essentially, New York and New Jersey have tried to do just that with subsequent legislation. I don't think that's going to pass muster when those laws are challenged.
Well, that was going to be my next question. What can activist states, largely in the Northeast, but then again, that's where the problem usually is anyway. What can states attempt to do to skirt this ruling?
So they can deem places sensitive that weren't otherwise deemed sensitive. I mean, the Supreme Court essentially said that places that have historically been deemed sensitive, like schools, government buildings, courthouses, those are probably constitutional restrictions. They said that's not an exhaustive list, but it would have to be a pretty well-known and well-traveled restriction in history, historically speaking, in order to pass constitutional muster. So that's one way they're going to try to do it. Then you see states like Rhode Island, which are going to try to limit the use and type of weapons, the firearms that are going to be available. The high capacity magazine ban is a perfect example of that. The problem with that they're going to run into, in my opinion, with that is there are already challenges in the pipes waiting for the Bruen decision to be issued on the high capacity magazine bans from California, for example, that were waiting to see how the Supreme Court ruled. What happened was, after Bruen, the Supreme Court granted certiorari on those challenges. They vacated the decisions of the courts of appeals, the federal courts of appeals, which upheld those restrictions, and remanded the case to the courts of appeals to redecide them in conformity with the standards set forth in Bruen.
Wow.
And the standard set forth in Bruen says the only restrictions that will be valid under the Second Amendment and the 14th Amendment will be ones that are rooted, deeply rooted in historical tradition in this country, in existence at the time or around the time of the ratification of the Second Amendment.
Wow.
Or they're very, very, very similar analog that may exist today.
So that leads us, of course, to the next step. And folks, if you're just joining us, Chaz Calenda, attorney at law, has returned live after a couple of hectic weeks out in the real world of Rhode Island. And we're taking a look tonight at the practical impact of the Bruen decision, focusing heavily, obviously, on Rhode Island law. This is a Rhode Island show, but also establishing some broad-based themes as how it can be applied to other states. So jumping in now, we get back into this situation where, and I'll put it bluntly, Rhode Islanders and citizens of other parts of the country have to once again litigate for their rights. Is
That's
that
right.
At what cost to the state and at what cost to the individual taxpayers?
Significant cost to the taxpayers for sure. I mean, to challenge, we've talked about this before, Pat, that to challenge a denial of a concealed carry permit in Rhode Island, it must go to the Rhode Island Supreme Court on a petition for writ of certiorari. It's entirely discretionary for the court to decide whether or not they're even going to hear your challenge. And at that level, it is quite an undertaking for someone who of limited means, or even people of modest or moderate means, to do that. It takes years, it takes money, and you have no guarantee that the Supreme Court's even going to hear it. Several bills have been introduced in Rhode Island General Assembly over the years to create a path of challenge in the Superior Court. So it could be more like going to court would normally be. You file a suit, you bring it before a judge or a jury, and you let it decide. That's not how the Supreme Court works.
You forgot the interim step. You bring it to a judge, and then the state engages in discovery for 10 to 15 years, and then by the time everyone has passed away, then we actually get to the crux of the matter. So never forget the never-ending discovery process here in the halls of Rhode Island justice. But at some point, you've got a state acting, I'll call it extra legally, effectively judge and executioner of a constitutional right, using, if you will, the Kafkaesque nightmare of virtually any court system in this country, not just Rhode Island, to engage in legislation by the judicial channel. What can Rhode Islanders do when you've got, in your opinion, and it's a pretty good one as usual, in your opinion, the state is engaging in that type of obfuscation?
Well, when you say the state in this particular situation, Pat, it comes down to it's the Attorney General, because it's ultimately the Attorney General's responsibility to ensure that the laws are consistent with the state and federal constitution. And when you challenge a police chief's denial, it's their city solicitors that go up to the Supreme Court. When you challenge the AG's denial, it's the Attorney General who goes to the Supreme Court. But it's really the Attorney General who had the opportunity here to come out and say the right thing and do the right thing following Bruen. He failed to do that because when he was asked by Matt Allen yesterday, doesn't the statute that affects the Attorney General's permit, isn't that now unconstitutional in light of the language in Bruen? And the Attorney General said no, because if it was, I'd be out of the licensing business and I couldn't license security guards or people who need to have permits for business like that. So it would be a problem for Rhode Islanders altogether if I got out of the licensing business. That's the wrong answer. That's the answer that he wants people to hear because it's the most extreme answer. It's the one that says, oh my God, Rhode Island would be in danger if I was not able to engage in this unconstitutional process to decide who's going to get a permit and who's not going to get a permit. His answer should have been, I am compelled to find, by virtue of the decision in Bruen, that self-defense, the desire for one to engage in self-defense by carrying a firearm on his or her person outside their home, is now a proper purpose by law and under our Constitution. So I have no authority to say no to that applicant who comes to my office to issue one of my permits because he has not shown a proper need, or he or she has not shown a proper need. That would have been what somebody who is not being political, somebody who is actually engaged in the protection of a constitutional right, should have said. And then he should, if he wanted to, he could have said, the legislature needs to take action to define what suitability means. The legislature needs to take action to determine whether or not this statute that governs the Attorney General's permitting process can stand in light of the Supreme Court's decision. But until then, I am compelled to find that self-defense without any particularized need is a proper purpose and meets the requirements of the statute in order to get a permit from my office. Instead, he engaged in fear-mongering.
So what do Rhode Islanders do next?
Well, if you'll excuse my self-promotion, you'll have to, I would say, vote him out this coming November, when it will be myself and him on the ballot. Because regardless of what my political opinions are, and I think everybody can probably figure out where I stand, regardless of what my political opinions are, I agree that a right is a right. A constitutional right is a constitutional right, whether I like it or I don't like it. And regardless of what my opinion is, I'm going to fight for all of the constitutional rights, and particularly when the Supreme Court has just recently ruled that not only is this a constitutional right, it's a fundamental one. And the state has the affirmative duty, the affirmative burden to prove that any restrictions they put on that right are deeply rooted in our nation's history and tradition. That is a tall order, and that is an exacting standard. And if you can't do that as the state's chief law enforcement officer, you're in the wrong job.
Yeah. It's astonishing when you look at the totality of events surrounding 2A, starting with those terrible, terrible massacres in Uvalde and places like that, and then coming full circle, if you will, through Bruen, through the state's reactions to Bruen, and now the one good man, as it's often referred to in the Second Amendment world, standing tall at a shopping mall and engaging in an almost clinical display of skill, accuracy, presence of mind, bravery, not only in just his returning fire to the assassin, but at the same time as it has been presented from the videotapes by law enforcement in that community. And I just find this astonishing. I have to reflect on this for a second. The presence of this young man, not just to react in such a clinical, disciplined manner to the events, but to simultaneously guide people to safety in this matter of seconds.
It's incredible. And this is what we in the Second Amendment community train our members for. That we don't train them to be the hero, but we train them how to be disciplined, train them how to have the presence of mind to act appropriately, safely, and in the best interest not only of themselves, but of those who they can protect if necessary, and to have the poise to do it. This is why we have gun clubs. This is why we have the rigorous training that our own community exerts upon itself, to hopefully have people like this young man in places where they can do some good. And to do some good is not doing this justice. I mean, it's an amazing set of facts that this young man was able to to navigate through this with such poise, such proper temperament, such accuracy, such safety. Um, it's incredible, and he deserves all the kudos he's getting.
And it speaks largely to the concept that training and discipline from a skilled adult not only gives a young person the skills to use a firearm, but also the temperament and the respect for the power and the danger if a firearm is used either improperly or aggressively. And I've often held that the way to really develop a sense of safety for firearms is not to teach fear of firearms, but take an individual like Brendan Jacobs here in the state of Rhode Island, who works exhaustively with young people, teaching them all of the above. Skill, respect, maturity, safety. And those young people know how to work and around and be in the presence of a firearm. And it just strikes me that maybe it's time to get back to those virtues. That teaching people to cower in a closet might be part of the formula, but at the same time to be at least comfortable in the presence of firearms, to be at least of mind within the presence of firearms. And we've clearly gotten far away from that. And I have to tell you, after looking at events in the last few months, the tragedy in Uvalde compounded, not caused by, but compounded by a reliance on law enforcement that I have to tell you, if you go to Marjorie Stoneman, if you go to Uvalde, if you go to so many situations, I'm not here to diminish law enforcement, but I will tell you, from my perspective, I'd love your thoughts on this, that an exhaustive reliance on other people to protect you can absolutely put you in harm's way.
You're right, Pat. And many law enforcement agencies have said the exact same thing themselves. Many times they just cannot get to these situations fast enough to prevent the casualties and the tragedies that have been going on. It certainly was the case. Obviously, we saw that in Uvalde. We've seen it in other places, but even in the situations where it may not be a school or a crowded place, many times it takes law enforcement longer than it would take someone who was properly trained and disciplined with the proper temperament to defend themselves in that situation. That's something that we need to be teaching people. We don't want them to be afraid to pick up a firearm if they need to protect themselves. Right. We don't want to install fear in them of firearms.
Right.
We want them to be able to use, if necessary, to protect life and liberty.
Yeah. It's disturbing to see these issues politicized. It's disturbing to see organizations use fear for the purpose of raising funds. It's disturbing to see fear used for political gain. And I am kind of pointing to one side. And
it's coming from one side.
Right. And I'll just leave that hanging there. What are your predictions? You were coming into the never-ending legislative seasons will come around. From my takeaway from your analysis, and I think this is a critical point, so confirm or correct me, is that this ruling is so defined, so well written, and I know people hate that, Because when it comes to the world of the Constitution, I'm an absolutist, I'm a strict constructionist, call me what you will. But as the Constitution currently exists, there aren't a lot of workarounds to massage your way out of this, as there has been even post-Heller. So it's either conform or, again, subject your locality, municipality, city, state, whatever, to yet more costly, if you will, litigation, and more chaos and confusion at the level. Is there any way around this for these activists to misconstrue or reconstruct or redefine or whatever?
Sure. Is there a legal way that's going to stand up in court? I don't think so. Not the way that they're going to want to do it. At least that they stated publicly. I think this magazine ban is going to fail. I don't know that it will happen here in the District of Rhode Island. I think it's actually going to be addressed first out in the Ninth Circuit, since that matter has been remanded from the United States Supreme Court to be redecided in conformity with Bruen. So I think we're going to see a decision out of there that's probably going to go the other way now, in light of the guidance in Bruen, which would mean that the magazine ban would be struck down. I'm sure they'll try to reappeal that to the Supreme Court. I don't see the Supreme Court taking that case. Which would leave the ban in place for the Ninth Circuit. And I think the other circuits will have to have no choice but to follow suit. That doesn't mean that they actually will fall right in line. I think we're going to see years of litigation because the states that want to put these barriers up, the states that want to make you jump through these hoops, figure it'll take years before we finally get a definitive ruling that our new laws that we've just made are not good. And that's unfortunate, because I don't think we should have to go to court every single time the Supreme Court rules to see just how far we as a state can push it, or we as public officials can push it before we finally get slapped down by a court. Right. That's engaging in gamesmanship and partisanship that's not needed.
Right. And brinksmanship should not be our public policy.
No, it should never be our public policy, despite whatever your personal opinion is. We're playing with people's rights. Would people accept that if we were playing with the Fourth Amendment that way, your right to be secure in your home and your person against unreasonable searches and seizures? No, I think we'd have an uproar in this country if states were trying to roll back that constitutional right. Would people accept the fact that we would take away religious freedom in this country step by step, or constantly introduce laws that tries to roll back religious freedom? No, they would not. It would not accept that one bit. How about rolling back the voting rights? I mean, right. People are up in arms over having to show an ID to vote. Yet they want you to jump through more hoops to exercise your Second Amendment right to keep and bear arms than exists for any other right. I don't know of any other right where you have to pay money to exercise it. You got to pay. I mean, yeah, okay, $40, not a ton of money, $40 to get a permit. You have some towns who are trying to issue a $300 administrative fee on top of that. You've got to go out there and pay for training. You've got to do all these things before you can actually exercise this constitutional right, the Second Amendment, that don't exist on other fundamental rights. Do I have to pay to go vote? No. Do I have to know anything about American civics to go cast my vote? No. I mean, these are things that just don't exist. But it's okay, and it's still okay. Unfortunately, right now, that these hoops exist, and some of them perhaps should. Training, I think that you should be trained before you are holding a deadly weapon or could possibly hold a deadly weapon in public. I think you should have some sort of training. That's my opinion. Would that pass constitutional muster? Probably, but there may be certain training regiments that they would find too burdensome. because it is such a fundamental constitutional right. So, to me, although Justice Thomas proclaimed it in Bruen that the Second Amendment is no longer a second class right, it still in many ways is,
Right.
because of all the hoops that are required to jump through just to, in some cases, get a gun, in some places, own a gun, purchase one, and particularly carry one.
I will say, generally speaking, there's an historical irony in Rhode Island being the constitutional hell. And I'm not just talking about the Second Amendment. I'm talking about the Fourth. I'm talking about the Eighth, amongst others, and even in a lot of degrees, the First. Uh, Given Rhode Island's historic representation of the Constitution back as we talk about the founding fathers, I'm hoping that this is the harbinger for what I'll call Rhode Island constitutional reform, for lack of a better term, on all of these issues moving forward. I know personally I'm going to be waging war on our state's failure to support the Eighth Amendment, both in terms of, bail issues, with regard to, post incarceration, and I'm of course talking about the treatment of prisoners in solitary confinement. First Amendment, it's amazing the degree with which we have exacted political strictures on our electoral system, and I'm not including the right to vote. I'm talking about party status. I'm talking about the requirements that various political groups have in order to conduct what's considered normal business in this state. So this might be the beginning of a fascinating period in Rhode Island history if you are a student of the law, or if you're like me, an amateur observer. Let's see how it rolls forward. This story is not completely written yet, is it?
No, it's not, and I agree with you, Pat. That I really hope this is the beginning of that awakening here in Rhode Island. That really needs to happen. It's that's just not a political opinion. It's just a reality when you look at it from a legal perspective,
Right.
and a political perspective. I was really hoping that we would have some sort of clarity, some sort of movement from, as a result of this case, that would give definitive guidance as to how we can be in compliance with our federal constitutional right. But the Attorney General of our state, the current Attorney General of our state, has said status quo. There are no changes, and actually embraced police departments continuing to use their open-ended discretion when they're evaluating these permits. And he said he would not change his practices one bit when he's issuing his permits. So we're really in the same place we were pre-Bruen that we are now in post-Bruen here in Rhode Island, because the Attorney General said Bruen has absolutely no effect here in Rhode Island on us.
Wow. Bring us home, counselor. On that note, bring us home.
Well, as always, Pat, I enjoy discussing these issues of grave importance here with you on Coalition Radio Network. I always appreciate your insight, and I appreciate the discussion. And this has been yet another episode that we tackle important legal issues here on Chaz Calenda, Attorney at Law. You can find us here and find me here on Wednesday evenings on the Coalition Radio Network around 8:30 p.m. I am Chaz Calenda, and I'm an attorney at the law firm of Inman & Torgy, 1500 Nooseneck Hill Road in Coventry, Rhode Island, 401-823-9200. If you're in need of legal assistance, I am there for you. I am also the presumptive Republican nominee to be the Rhode Island Attorney General. This coming November, I will be on the ballot has been confirmed by the Board of Elections, and I will be challenging the incumbent Attorney General, Peter Nerona, for that seat this year. So if you're interested in learning more about my campaign, you can go to my website at CHAS, CHAS, the number 4, AG.com. Find out all about me. Find out how you can get involved with my campaign, how you can learn more about me, and how you can donate. You can also find me on Facebook, Twitter, and Instagram, amongst other places on the internet these days. But we will be back here for another episode of Chaz Calenda, Attorney at Law. On the next Wednesday, we are able to get here. As you know, political season is in full force and effect. We are in the middle of it, so forgive us if we can't be here every Wednesday, but we will try to keep you all informed of our of our doings going forward. But I'd like to thank everyone who joined us here on the Coalition Radio Network. And before you leave, or before you say goodnight for the night, why don't you check out some of our sponsors, like Brewed Awakenings, check out Yacht Club Soda. They are great local businesses. I would highly suggest going in there, get yourself a root beer, get yourself a coffee at Brewed Awakenings. I suggest, as any Rhode Islander and any local should, support your local businesses and support those who support your rights here in Rhode Island and across the country. So thank you once again, everybody, for joining us. Thank you, Pat, for the lively discussion tonight. And we'll see you all on our next episode of Chaz Calenda, Attorney at Law, here on the Coalition Radio Network. Have a good night, everybody.
Good night.
To take home the Golden Gloves, you've got to put in the work, and you've got to be tough as nails. Ashley Kalis was driven to achieve. Today, Kalis is still fueled by that same hope, grit, and determination. A mother of 3 school-aged boys and successful business owner who ran testing and vaccination sites across the state. Kalis is the fighter Rhode Island needs right now because it's time for a change. Ashley Kalis for governor.